Former Trump White House Chief of Staff Mark Meadows has lost another attempt to move his Georgia election interference case from state court to federal court.
A federal appeals court upheld a judge's ruling from September rejecting Meadows' latest bid to move the case. According to the ruling, Meadows' actions were not related to his official duties while working in the Trump administration. Let's bring in NBC News legal analyst Danny Cevallos for more on this. All right, so Meadows, one of 19 people, along with former President Trump, hit with felony charges here related to alleged attempts to try and keep Trump in office after losing the 2020 election. He pleaded not guilty. The judge who heard the appeal said the law, quote, does not apply to former federal officers. What else should we take away from this ruling?
So this was not a motion to dismiss. This is removal. In other words, it's like a castle move in chess. If you're a defendant and you're in state court and you don't want to be in state court, sometimes you can remove the case unilaterally without the plaintiff or the prosecution wanting you there up to federal court. It happens 99% of the time in civil cases. Federal criminal removal is very, very rare. It doesn't happen very often. This is one of those potential instances. And the defendant here tried to get it up to federal court, and the appeals court essentially said, looking at the removal statute, there are two reasons why the defendant failed here. Looking at the removal statute, first, you have to presently be an officer. And the support for that is you look at another section of the statute and it says, in other cases, as long as you were an officer at some point in the past, in a prior life, whenever. But in this particular statute, it says whoever is an officer. It uses the present tense. The defendant is no longer an officer. He is a private citizen. He cannot avail himself of the benefit of that statute. And then secondly, as you said, the second reason, which would have been independent anyway, was that he was not acting as a federal officer. He was acting on behalf of a campaign. So two independent reasons why this case does not stay in federal court. It goes back to state court, which really at the end of the day was a strategic advantage only. It wouldn't have ended the prosecution.
Remind us why it is that he does not want this going down in Georgia.
Because, again, it's really just a tactical thing. And I've removed plenty of cases. It really is a way of taking, and I think it would have been really effective in this case, you take the prosecution out of their home base. Think about it. In state court, the prosecutor's office, I believe in Fulton County, is either across the street or in the same building. That's pretty par for the course. Most prosecutors have their offices in the same building. They know the judges. They know the halls of the courtroom. They know the procedure. If he had been successful in taking those prosecutors out of the courthouse that they know and into federal court with its own rules of procedure, different judges, even something as simple as having to take a cab a couple blocks, that is a significant strategic advantage. Would it have won the case? Not sure, but you take every advantage you can get in this game of litigation.
So Meadows faces two counts. One's a violation of Georgia's RICO Act, the other solicitation of violation by oath by a public officer. Where does this go from here? Is it looking like things could be on time as far as trial, or are we going to expect a lot of delays?
Everybody asks me to forecast how long all of these criminal cases will take. The rule of thumb is, it seems in Georgia, where I do not practice, but from looking at reports about Fulton County cases, that is going to be the slowest case of all of the Trump cases. Number one, it's in state court. State court always moves more slowly than federal court. Federal court has a less crowded docket, and they have an imperative. They have a mission to move cases along. They've got the Speedy Trial Act. Cases move faster in federal court. In state court, they move slower. And just to give you an example, and I've used this example ad nauseum, the last major RICO case in this county had jury selection for 8 months. Just to give you an idea. So I've been saying, and save the tape, but don't really save the tape. I've been saying that the first witness in the Fulton County case will not be called until 2025, not 24. 2025. That I'm allowing for a long jury selection period. First witness, 2025. You heard it here.
Far more likely we're going to see some of the other Trump cases.
Absolutely.
All right.
Absolutely.
We'll
Thank you so much, as always.
If you're wrong.
Please don't.
Thanks, Danny.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.